Good afternoon, everyone. We'll bring the hearing to order. I want to thank everyone for being here. The mission of the EPA is to protect human health and the environment, and lately the EPA has ventured well beyond its mission. In recent rulemakings, its recent rulemakings are an unprecedented power grab that's infringing on the rights of both the individuals and small business owners. The results on our economy are potentially devastating, and the EPA needs to reevaluate its decisions. These rules have real and direct consequences for small businesses, and the American public deserves to have a complete picture of the costs and benefits of all of these rules. Unfortunately, the EPA seems focused on telling one side of the story and ignoring the other. What the EPA is not revealing is how its rules will affect small businesses. The EPA is required to tell the story by the Regulatory Flexibility Act, or the RFA. The RFA requires EPA to go through the common sense process of assessing how its rules will affect small entities and whether there are less burdensome ways to meet their objectives. Instead of complying with the law and getting input from small businesses through formal panels and analyzing small business impacts, the EPA has ducked these rulemaking requirements. Unfortunately, small businesses won't be able to duck the power plant regulations or Waters of the United States rule once they're finalized. And they're being required to comply with rules, pay the costs, and face the consequences. While all small businesses want clean air and clean water, they also want rules that are very clear and rational. Small businesses want to know what they'll be required to do, what the costs are expected to be, and how their operations will be affected. And last but not least, small businesses want to be treated fairly in the rulemaking process. I hope this hearing is going to be a wake-up call for the EPA, and avoiding its obligations under the RFA is just simply not accessible. For the past year, the committee has been working to get the EPA to testify on this topic, and I very much want to thank Deputy Administrator Perciasepe for joining us today, and I look forward to discussing this issue, and I, again, want to thank you for being here. I now yield to Ranking Member Velasquez for her opening statement.
Thank you, Mr. Chairman. A clean environment and economic growth go hand in hand. Between 1970 and 2011, air pollution dropped 68%, while private sector jobs increased by 88%, and GDP grew by more than 200%. This is not coincidence, as studies continually show that environment stewardship is not only good for our families, but also for our businesses. Today, the EPA plays a vital role protecting the public health and safety by implementing a vast array of environmental laws, which in turn support our economy. Through its implementation of the Clean Air Act, we have seen significant improvements in our nation's air quality. In a given year, enforcement of the Clean Air Act has saved 160,000 lives, prevented 1.7 million asthma attacks, and stopped 13,000 heart attacks. It is estimated that 13 million missed workdays are prevented thanks to the cleaner air we enjoy, boosting economic productivity. We have also seen similar benefits from the EPA's enforcement of water regulations. Since the enactment of the Clean Water Act, billions of pounds of pollution have been kept out of our waterways, doubling the number of safe areas for swimming and fishing. As a result, Americans are healthier, our waterways are being remediated, and industries like tourism, fishing, and recreation, which are dominated by small businesses, are seeing greater opportunities. While it is fair to say that these outcomes are positive and that EPA is justifiable in pursuing such goals, the agency must always be mindful of how new rules and regulations impact our nation's small firms. To this point, our committee has already examined several EPA regulations and the agency's obligations under the Regulatory Flexibility Act. What these hearings have shown is that the small business impact can vary from rule to rule. When it comes to electricity generation, it is clear that the direct costs are borne mainly by large utilities. However, with regard to the discharge of certain chemicals into the water, small businesses and farms are likely to bear more of the actual costs associated with the regulations. Yet, EPA determined neither rule will have enough of an economic impact of small firms to trigger RFA analysis. During today's hearing, I hope to hear how the EPA is implementing its obligation under the Regulatory Flexibility Act, as well as conducting outreach to small firms. Perhaps most importantly, I want to know how it determines not to meet the full requirements of the Act. There's no doubt that small businesses want to protect our environment and should, in many regards, be an ally of the EPA. Not only are they leading the way when it comes to environmental technologies, but they can also help the EPA craft regulations that promote clean air and water without overburdening in the industry. It is my hope that today's hearing will help bridge the gap between the EPA and the small business community, resulting in a cleaner environment and a stronger economy. With that, I thank Deputy Administrator Pershapi for his participation today, and I yield back the balance of my time. Thank you.
Thank you. In 2009, the Honorable Bob Perciasepe was appointed by President Obama and confirmed by the Senate to serve as the Environmental Protection Agency's Deputy Administrator. And for nearly 4 decades, he's worked on environmental issues from both within and outside the government. Mr. Perciasepe previously served as the head of EPA's Water Office and later its Air Office, and prior to becoming Deputy Administrator, he was the Chief Operating Officer for the National Audubon Society. Mr. Perciasepe has also served as Secretary of Environment for the state of Maryland. Director Perciasepe, thank you for taking the time to be with us today, and your written statement is going to be entered into the record. So please give us your oral statement.
Chairman Graves, thank you. Ranking Member Velasquez, thank you for those comments, and thank you for the opportunity to testify and answer questions of the members. I'm here today to talk about EPA's actions under the President's Climate Action Plan and also under the EPA and U.S. Army Corps of Engineers' recently proposed rule that would clarify jurisdictional scope of the Clean Water Act. Climate change is one of the greatest challenges of our time, threatening human health, welfare, and our economic well-being, and if left unchecked, will have devastating impacts on the United States and businesses. That's why President Obama laid out a Climate Action Plan in June of 2013, in which he directed EPA and other Federal agencies to take steps to mitigate the current and future damage caused by carbon dioxide emissions and to prepare for the anticipated climate change that have already begun to be set in motion. EPA plays a critical role in implementing the plan's one of its first pillars, which is cutting carbon pollution. The President asked EPA to work with states, utilities, and other key stakeholders to develop the plans to reduce carbon pollution from future and existing power plants, the largest source of carbon dioxide emissions in the United States. In June of this year, EPA proposed a clean power plan for existing plants. The plan is built on advice and information from states, cities, businesses, utilities, and thousands of people about the actions they are already taking to reduce carbon dioxide emissions, and it aims to cut energy waste and leverage cleaner energy sources by using a national framework to set achievable state-specific goals, and it empowers the states to chart their own customized path to meet those goals. The EPA's stakeholder outreach and public engagement in preparation for this rulemaking was unprecedented. Starting last summer, we have virtually met with thousands of people and had hundreds of meetings with a broad range of stakeholders, including small entity interests such as municipal and rural electric cooperatives. Now we are in the second phase after the proposal of our public engagement, and it has already begun. We have already had dozens of calls and meetings with states and other stakeholders, and more formal public process includes a comment period that runs through October 16th of this year. Public hearings are being held this week in Atlanta, Denver, Pittsburgh, and in Washington, D.C. In addition to the President's action plan, I also want to take a minute to talk about the recently proposed jurisdictional rule under the Clean Water Act. In recent years, several Supreme Court decisions have raised complex questions regarding the geographic scope of the Clean Water Act, and for nearly a decade, members of Congress, states, local officials, industry, agriculture, environmental groups, and the public have asked our agencies, the Corps of Engineers and EPA, to make the existing rules on the book more consistent with the Supreme Court's rulings. For the past several years, EPA and the Corps have received input from the agricultural community while developing the proposed rule. Using this input, the EPA and the Corps worked with USDA to ensure the concerns raised by farmers and agricultural industry were addressed in the proposed rule. The proposed rule does not change in any way the existing clean water exemptions associated with agriculture, ranching, and forestry activities. EPA also sought wide and early input from representatives of small entities. While formulating a proposed definition of this term that reflects the intent of Congress consistent with the mandate of the Supreme Court's decisions, and that was reflected in our proposed rule. EPA has prepared a report summarizing the small entity outreach to date, the results of this outreach, and how these results have informed the development of the proposed rule. Since publishing the rule, the agencies have met many times with small businesses and other entities. Most recently, the agencies participated in an SBA-sponsored roundtable on July 21st. We look forward to continuing these efforts into the future and before we finalize the rule and during the remainder of the public comment period as we write the final rule. Thank you again, and I'll be happy to answer your questions, Mr. Chairman.
Thank you, Administrator. I appreciate it. Administrator McCarthy recently was in Missouri, my home state, and she was talking about obviously waters of the United States, and she made the statement that the concerns of farmers and others, and I want to make sure I say it right, that the proposed rules and the concerns about the proposed rules were silly and ludicrous, which I'd submit that the concerns of farmers and small businesses and everybody out there are certainly not silly or ludicrous. And I think a lot of these concerns may have been identified if the EPA had complied with the RFA, and that is my basic question here today, is why the EPA did not convene small business advocacy review panels. That's what it requires. They are formal panels, and you said in your statement that you've gotten input from the ag community. I'd like to know what that is, and when you say small entity outreach, what does that mean in terms of, and why didn't you all do what the RFA does require? Because, informal outreach is not small business review panels.
I'm sorry. Thank you. I'll get the hang of that in a second here, Mr. Chairman. Under the RFA, whatever the regulatory agency is, not just EPA,
yes,
is required to look at the small entities subjected to the rule. And this is the interesting thing about the Waters of the United States rule that we call it. It is a definitional rule. It defines where the other parts of the Clean Water Act will actually apply. So it doesn't directly impose any requirement on anybody if they're not discharging pollution. So it doesn't directly impact large businesses or small businesses in any direct way. And so the jurisdictional determinations of whether the Clean Water Act would apply or not, and whether a state agency who's implementing the Clean Water Act under the arrangements under the law would have to require an entity, small or large, to get any kind of permit would only be related to whether or not they were going to discharge pollution. And this regulation does not regulate discharges of pollution, just where the existing permit programs would have to work. But also, more importantly, we are reducing the scope of where the Clean Water Act applies from the current on-the-books regulations that the Supreme Court was acting on in the last decade. And so we're not expanding where permits would be required. And so when we looked at all of that together, we didn't see the applicability under the Regulatory Flexibility Act. However, we did see a desire, as we almost always have, of being able to engage all stakeholders, including small entities, and we've had a process underway to do that, and we will continue to do that. We're planning more roundtables as well.
When you say no discharge, discharge can include dirt and sand, runoff, water, rainwater.
Well, rainwater is not a pollutant.
Well, but when it interacts with dirt and sand, and you're carrying dirt and sand, that's considered a pollutant by the EPA.
Well, it would have to be, let me just be clear. The jurisdiction of the Clean Water Act is where the existing laws and regulations would apply, not any new requirement. So if you have to get a permit now, you would have to get a permit under this. But if you don't have to get a permit now, it's most likely you would not need a permit under this. If you plow, plant, and harvest, walk cows across a field, all these other things that you do in normal conduct of agriculture, if you do that now, you will be able to do that under this rule without any additional requirements on EPA, from EPA or the Corps of Engineers.
Well, we go back to my original question before I do. You did say that you are reducing the scope in terms of the Clean Water Act, didn't you?
Reducing.
In your economic analysis, the EPA's economic analysis, you say there's a 3% increase in jurisdiction.
So the existing regulations were done in the 1970s and modified in the 1980s, and they have a very broad definition of what waters of the United States are. And essentially, we're asking field biologists to go out and determine whether any place on the landscape where water may be running has some impact downstream on interstate commerce. That's what the Supreme Court said we cannot use interstate commerce as a way to do this. It has to be based on some kind of scientific basis. I think they use the term of art of significant nexus. So when we went back and looked at 20,000 different determinations that were done in the last 5 years, and we applied it as strictly as we could, we saw some where the applicability would go away, and we saw some where they had made the wrong call on the ground, even with the old regulations. So we were being conservative and said this looks like it could increase the amount of positive determinations for jurisdiction by 3%. But the existing regulation is much more expansive than that and hasn't been applied completely uniformly around the country. So this will actually constrict that.
Well, why didn't the EPA do small business, the formal small business advisory review or advocacy review?
Well, we didn't do it because, and it isn't that we didn't want to talk to small business, but we didn't have the formal panel because the panel is for the direct impact on a significant impact on a substantial number of small entities. And the direct impact is not here from this rule. The impact, if any, and we think there will be not much, if any, is from the existing regulations that would apply.
So what you're saying is that you determined, the EPA determined that there wasn't going to be an impact, so you didn't have to comply with the RFA, which is the process of determining if there's an impact.
Well, we went through that analysis.
From small businesses to help make that determination.
Yes, I believe we're required to lay out our rationale for what I just said in more detail in the proposed rule.
Well, I think this is far-reaching. In fact, the term navigable waters is used some 80 times in the Clean Water Act. When you come back and you do something that's so far-reaching, and we use new terms like significant nexus, or in one of the expansions of this too is now a jurisdictional or a water that's adjacent to a jurisdictional water, which I don't even know what that means in terms of how expansive that could be. That could include anything. And it comes back to as well when you're making that determination on discharge or what that significant nexus is. That's an extraordinarily subjective determination, obviously going to be made by the EPA. I think with the impact that's out there with this, that it really bothers me that you all determine that this isn't going to have an impact, because we believe it does, in a big way. And to say that we don't have to comply with the RFA because we don't think there's an impact, I think is wrong. I've called on you all to withdraw this rule. I'm asking again. I think the EPA needs to withdraw this rule and go through the process the way it should be gone through and follow the law. And I'm very disturbed by that, and very disturbed by some of the things that have been brought out just now. I wasn't expecting I wasn't expecting some of your answers. With that, I'll have some other questions later, but I'll turn to Ranking Member Velasquez.
Thank you, Mr. Chairman. Deputy Administrator, the Clean Power Plan provides states with some flexibility to meet emissions reduction goals as they see fit. What happens if states fail to submit their plan by the deadline or EPA concludes a plan is not satisfactory?
You know, it is our full hope and aspiration that that won't happen. That's why we're spending a lot of time with every state. We've tailored this rule so that it's tailored for every state, and we're meeting with every state to try to work through how they can make their plans successful. So, you know, the law has provisions in it that on when states fail to do plans under the Clean Air Act, the EPA has the authority to propose a plan. We do not want to do that, and that would not be our objective.
Okay. In your testimony, you highlighted that many industries, including agriculture and forestry, will continue to be exempt from most permitting. Do you expect the new rule will necessitate additional industry exemptions?
You're talking about the water rule?
Yes.
Yes. Well, under the Clean Water Act, agricultural activities are exempt from the rule. From the jurisdiction of the Clean Water Act, so that even if a water is jurisdictional under the proposal, if you're doing agricultural activities, you're exempt. You do not need to comply with any permitting processes, and we're not changing any of that. One of the things we've tried to do is clarify issues that farmers have brought up to us concerning ditches, where they may do some ditching to drain some upland areas when it rains, or even industry may do some on their industrial lot, or some ditches at the side of highways. For the first time, we've made it clear that those are not jurisdictional. Those would not be under the jurisdiction of the Clean Water Act.
Okay. Deputy Administrator, I guess that you understand by now that there is frustration in this committee regarding the fact that we have the regulatory act that would allow for agencies to compel or create a panel review process so that it will give a voice to small businesses. And I think that if you do that, the agency wins and small businesses also will win, because you will issue a better regulation when you have input from small businesses. And small businesses will be more satisfied because they feel that you have been able to listen to them. I don't know why the reluctance or what. I just do not understand how do you conclude or come to the conclusion that there is not direct impact on small entities, because you haven't provided us the process in which you arrive to that conclusion.
Yeah. Well, certainly, I want to be able to provide that to the committee, and we will endeavor to do that. But whenever we do a rulemaking and we make a decision in our proposal that the direct impact, there may be indirect impacts, but the direct impact is not from the EPA rulemaking, then the law prescribes that does not require a panel to be set up. But that, I want to be clear, that doesn't mean we shouldn't reach out to small businesses.
And I understand you did.
And work with them.
I understand
and we
you did, right? But my understanding is that the outreach took place 3 years ago, and the language now is different.
On the water?
Yes.
Yes. We had a whole bunch of sessions a couple of years ago when we were working on guidance. People told us not to do a guidance, do regulation. We've proposed a regulation which was built on some of the work we did back at that point. But since that time, we've been working with SBA to do roundtable discussions. And as I mentioned, we had one on July 21st, and we are planning to have more before we would finalize the rule. Roundtable discussions with small businesses.
So would you please share with us what did you learn from that SBA roundtable?
Well, on the water side, believe it or not, we're learning that small businesses really want clean water. And it's pretty coming clear. In fact, there was a recent poll done by the American Sustainable Business Council that found that 80% of small business owners want protection similar to what we're talking about. That 71% said clean water is necessary for their businesses. So, but we're also finding that they want it to be, they want to be clear when they're in and when they're out of that jurisdiction. And so, one of our objectives is to take the existing regulations, which are, and see, one of the issues we have is people haven't looked at those old regulations back in the 70s and the 80s for a long time, and so when we put out a new one that's trying to replace it, they're only looking at the new one, and the old one is even vague, is very vague. You know, downstream interstate commerce, it's not a scientific principle. So we're trying to pull it back into a more defined place to provide that increased certainty, and that would be our objective, and that we're hoping to get more comment on that.
Thank you.
To clarify real quick,
Yes, sir.
because you keep bringing up the exemption, the ag exemption, but that's only Section 404, dredging. There is no exemption for ag under Section 402.
If they're discharging pollution, like from a point source of pollution.
Okay, that could include, again, rainwater?
No, non-point, if it's runoff rain, it's non-point source pollution, and it would not be covered under Section 402. It would have to actually be in a pipe and being just, you know, something that they're discharging. And Congress in 1987 asked that large animal feeding operations that discharge into a point source would be covered under 402. That's in the 1987 Clean Water Act amendments.
Mr. Lukemeyer?
Thank you, Mr. Chairman. Administrator Percisepi here. I want to thank you first. I know that one of the things I'm working on is the proposed rule that is out there with regards to wood burning heaters. I've offered a bill to stop the nonsense of what you're trying to do. And I understand that there is some discussions going on between you and industry folks, which I'm very thankful for and hope that proceeds. I think this is, I understand the need for conformity across the spectrum of this, but to go down the direction that we were going down there is pretty problematic for me. So I thank you for the willingness to work with industry. With regards to the other issues before us today, it is stunning to me when you make the statement, sir, that you didn't see the effect on small business from trying to define a word in the law. To redefine or clarify is going to have dramatic impact. When you say, if you just define the word customer, you redefine that, suddenly you have from a very small group of people to a large group of people. To take the word navigable out of this is unbelievable to me. And to not then go through the process of checking out and doing the due diligence and the small business report and analysis before this is either extremely naive and incompetent, or it's arrogance in its highest to be able to flaunt your authority by ignoring the laws, the rules, the process, the procedure. This is unacceptable. Absolutely unacceptable. Especially whenever you look at the fact that within this law there is also the word hydrologically connected, which means that all the waters, regardless of whether they're above ground, below ground, wherever they're hydrologically connected, in a rain situation, it connects everything. This is extremely important. Extremely important. I can't stress it enough, especially for rural parts of our country. And I offer you an opportunity to discuss it.
Well, thank you for that question. And you know, those are really those you're getting at the crux of the issue under the Clean Water Act, and we have to look at the body of everything that's been going on, and not just old rulemakings of the Corps of Engineers and EPA, but also the Supreme Court rulings and what they've been telling us to do. And they have consistently been clear that it is not just navigable in the traditional sense, but particularly when you're dealing with clean water, the stuff that flows into the navigable, if it's polluted, it will pollute the navigable. And so, you know, everybody from Justice Scalia to Justice Kennedy have made it clear that it's more than just the navigable. It could be seasonal. I think that's a quote from Justice Scalia. Justice Kennedy uses the words significant nexus. And to go back to your question, and I think this, Mr. Chairman, may get at some of yours as well, significant nexus is a new thing that the Supreme Court gave us. Yeah. So we're trying to find out how the purpose of the executive branch putting out a proposed regulation is trying to, and I have dicta here from Chief Justice Roberts telling us to do these regulations. So look, just one more second, I promise. So nexus is definitely hydrology, as you just pointed out. And what is the connection? Well, you could make the argument, as the chairman made, that rain falling is connected somehow. And so one of our jobs in this rulemaking, and one of the things we're most interested in trying to get back more input on, is how do we define significant? Everything might be connected, but it's not all significant. So back in the old regulation, it said if it had any impact, probable or any impact on downstream interstate commerce, what we're trying to use is the science of hydrology and say, well, it has to have certain characteristics that are identifiable by a hydrologist, that there's enough flow in that watercourse that it's frequent enough and enough that it creates these characteristics on the landscape. Otherwise, it's not significant. So we've tried to do that in this rule.
You just made my point, though, sir. Of why didn't you go through the rulemaking process that you're required to? Because you just admitted it's a tremendously impactful situation you're discussing here. And you don't think it's not going to impact small businesses when you just said it's huge, you've got the Supreme Court involved in trying to define things and sort of direct you in some of your activities, and it's not worthy of going through the process that you're required to do, to go through and figure out the impact on small businesses? Well, that's what the chairman's talking about, and what this hearing's all about today.
And we are working with small businesses and with the Small Business Administration.
Yeah, but you just talked about how important it was and how big a problem it is, and yet now we didn't go back and do what you're supposed to do, which is determine the impacts based on the effects of it. I'd see my time's over, but I'm stunning, absolutely stunning.
Mr. Tipton.
Thank you, Mr. Chairman, and I'd like to be able to submit for the record a letter from the Waters Advocacy Coalition. It is signed by 39 different organizations, among those the American Farm Bureau, the American Gas Association, Foundation for Environmental and Economic Progress, National Association of Home Builders, National Pork Producers Council, many others. The basic content of the letter is objecting to the insufficient analysis offered by the EPA on the impacts that this rule will have.
Without objection, submitted.
Thank you. Mr. Puricepi, I'm sorry. Okay, Bob. As the letter that I'm just referencing from the Waters Advocacy Coalition is noting, the agency certified the Waters of the United States rule as one that will not have significant economic impact on a substantial number of small entities. Yet the agency did not provide any factual basis for that certification as required under the RFAs. Did the EPA simply fail to do this because a factual basis didn't actually exist?
We provided an analysis to make the determination that the rule itself, looking at direct impacts, which is what we're required to do under the RFA, would not have a significant impact on a substantial number of small entities.
What do you qualify as a substantial number?
Well, it's more the direct impact than the number.
So we don't even know what the number is when we're talking about who's going to be impacted?
Well, we are not expanding the jurisdiction of the Clean Water Act. So any small entity that is currently covered by the Clean Water Act will continue to be covered by the Clean Water Act. Well, we're not making more of them covered.
Actually, you're saying not making more covered, but in your testimony you stated that people wanted to be clear whether they're in or out of jurisdiction, but under the determinations that are making, you clearly can expand jurisdiction.
But that's not what we're proposing. We're proposing to not add any new waters to these to what is covered and jurisdictional. We're trying to exclude certain things.
Is there a connectivity between all waters?
There is, but they're not all
So doesn't
significant.
that give you complete control?
They're not all significant, and we make it clear in the rule that they're not all significant.
Yeah, what's significant?
We've defined some hydrologic characteristics that would make a water significant.
What are they?
In the science of hydrology, if you look at a flowing area, whether it's flowing all the time.
Flowing year-round?
No, I said whether it's flowing intermittently.
What's
seasonal.
intermittently?
Not all year round.
Not all year round, so it could be 10 minutes?
Well, it could be enough that water flows there frequently enough.
What's frequently?
All right, you're not going to let me answer?
No, I'm just trying to get down to the actual definition because of the arbitrary nature of this rule.
It is not arbitrary, sir. And if you let me answer, I can give you some clarity. In the science of hydrology, you can look at a depressed area where water would flow, whether it flows full-time or part-time. Let's just use those plain English words. It will exhibit characteristics on the ground. There'll be a bed, there'll be banks, there'll be an ordinary high water mark. These are things identifiable to hydrologists. And if you don't have those characteristics, then there's not enough frequency of flow or volume of flow that would make it jurisdictional under the Clean Water Act. That is what we propose. That is limiting to anything that might have an impact downstream to interstate commerce.
What you've just described to me, I live in southwestern United States in Colorado. We get one rainstorm, and with the lay of our land, you can have a high water mark caused by a 10-minute flow that then disappears. So under what you're describing to me, a 10-minute flow that happens once a year then becomes abnormal.
An ordinary high water mark is not something from being wet 10 minutes ago. It's something that can be seen on the rock in terms of debris or discoloration of the rock.
Cut in the bank, or a cut in the bank of dirt?
Erosional features are not covered.
Erosional features.
We just excluded those.
I'd like to be able to move on just a little bit here, move in a little different direction. If you put out a rule under EPA, do you expect it to be followed?
Well, yes.
You do. Should you comply with the RFA and with NEPA?
Yes, we did.
You do? So is it appropriate right now under Section 104 of the existing Clean Water Act that both retroactively and preemptively you're shutting down projects before determinations have been made under NEPA and the RFA?
I can't answer that question because I'm not sure what you're...
Are you preemptively shutting down projects right now based off of the proposed rules, saying that you cannot proceed?
We have not done that.
What about, I'm sorry?
They haven't issued the rule.
But we've got a proposed rule.
Right, but we have existing regulations that are more expansive than the proposed rule.
Okay. Up in Alaska, I just read, is it the Pebble Mine? Is that right?
Oh.
Pebble Mine?
In the Bristol Bay.
Crystal Bay. Have you shut that down before the analysis has been done?
Our regional administrator made a finding that is out for public comment.
Does that comply with NEPA?
There's been no action taken on that.
No action, so it's not allowed to move forward until the action takes place?
They can do whatever they want while that action is under consideration. And that action is to look at an area of water that we would not want to see discharge into.
Okay. Thank you, sir. I don't know if we're going to have a second round. I'm way over time, Mr. Chairman.
We can. Mr. Collins.
Thank you, Mr. Chairman. Mr. Perciasepi, I got to give you credit. I think you knew you were coming into the lion's den today, and here you are. So I do give you a lot of credit. It's hard to defend the indefensible, and that's what your agency has sent you here to do. And for full disclosure, Mr. Perciasepi and I participated in a hearing a week or so ago on this very same issue on the Science Committee, and I will admit I concluded that hearing by saying to Bob that the public doesn't trust the EPA, farmers don't trust the EPA not to overreach, Congress doesn't trust the EPA. And at that point in time, I pointed out the rule should be withdrawn, plain and simple, and the EPA should start over. What we had in our committee hearing in science was we kept hearing words like confusion, uncertainty, misunderstanding, clarification throughout that hearing, and this was Democrats and Republicans alike. And I would like to also point out, we all know about gridlock in Washington. There is only one agency that unites Democrats and Republicans, and that is distrust of the EPA. Your agency has united us where it's very hard to do so.
Please don't talk, don't represent me.
Okay. Well, here's what I can say factually to our ranking member. A majority of Congress, 240-plus members, Republicans and Democrats, signed the letter that I authored to the EPA saying we don't trust you, withdraw the rule. That was a majority of the members of Congress. And your agency has continued to disrespect Congress, to go down your own road, and again, continue in this rulemaking when a majority of Congress, Democrats and Republicans, and on the Science Committee, the harshest questioning came from the Democrat side about this particular rule. And I just came from a hearing in Science on the Clean Air Act and the war on coal. And a former Obama administrative official from the Department of Energy summed up the EPA this way, to paraphrase: the arrogance of the EPA is beyond pale. The Department of Energy was not legitimately asked to participate in this, some of this rulemaking, and in fact, he called it a political agenda by the administration and the EPA. This is a former Obama administrative official less than 2 hours ago. So my question is very simple. Given the facts, the majority of Congress has asked you to withdraw this rule. Why won't the EPA withdraw the rule, start over? There is no rush. You're not under a deadline. There's no judicial deadline. What is the harm in listening to Congress and withdrawing this rule, clarifying all the misunderstandings and confusion and everything else, and come out with a clean rule? Why won't the EPA do that? Or will you do that? Let me start with, will you withdraw the rule? Yes or no?
You know, the agency always...
Yes or no?
No.
Okay, why not? Given that Congress has asked you to do so.
You know, you all have put the agency in a very difficult situation. We're trying to improve the situation out there, given the Supreme Court constantly telling us...
But let me go back to, why won't you withdraw the rule and start over? What harm is there in withdrawing the rule and starting over when a majority of Congress is on the record asking you to do so, Republicans and Democrats? What is the harm in doing that? And do the RFA. What's the harm? Is there any harm? Is there something we don't see? Or is it just the arrogance of your agency?
We continue with the uncertainty that everybody...
What is the harm in withdrawing the rule?
The harm would be in maintaining the uncertainty that currently exists, and we are not going. We're going to continue to try to solve that problem. This is just a proposal.
So again, let's just be clear. You don't care that a majority of Congress,
I do care,
who sets the laws,
I do
has
care.
asked you to withdraw the rule.
Well, I do care very much.
Then why don't you withdraw?
Because I need to fix the rule.
No, you need to withdraw the rule. Congress has asked you pointedly, withdraw the rule. You've just said, no, there's no legitimate reason, there's no timing, there's nothing but the arrogance of the EPA. Mr. Chairman, I yield back.
You know,
Go ahead.
I mean, I have a Supreme Court Chief
Correct.
Justice of the Supreme
That was
Court
my question.
who's saying, why don't the agencies do this?
Yeah.
And so, you know, there are three branches of government. I got one branch maybe saying, I have one branch who wrote me when I was the acting administrator saying, please do a rulemaking. Now I have that branch saying maybe we should withdraw it. I have another branch of the government, you know, I'm going right back to the Constitution here.
Right.
I have another branch of the federal government saying, when are the agencies going to get their act together and do a rulemaking? So, you know, I would
do it the right
propose
way.
that it would be in everybody's interest for us to take the comment.
Would the gentleman yield? It's kind of cynical. And look, I am a member of this committee for 22 years. I've been fighting the administration, whether it's a Republican or a Democrat, when I feel that things are not done right on behalf of small businesses. But I have to say that when it comes to repealing Obamacare, the Supreme Court is the law of the land. When it comes to the issue of the water, the Supreme Court is telling them that they have to address the issue. So we don't win in this House.
Just to clarify, was there a judicial deadline? I just asked to clarify. Was there a judicial deadline?
No, sir.
Mr. Schweikert.
Thank you, Mr. Chairman. And I'd like to submit to the record from a roundtable we held in Arizona about a month and a half ago, the transcript.
Without objection.
Thank you, Mr. Chairman. Mr. Persepi,
Yes.
and from now on known as Administrator Bob. How's that?
Deputy Administrator Bob.
Deputy Administrator Bob. And there's a rumor going around you're going to be leaving us in a few weeks. Is that true?
Yes, it is correct.
And this is how you celebrate your departure, is hanging out with us.
I know that I'm trying to represent my position of my agency and the President correctly here, but I view this as my solemn duty to do so.
And you were in front of the Science Committee a couple of weeks ago, and as I even shared with both my staff and even some of the members on the other side, I thought you treated me particularly fairly, because some of the discussion, having spent a lot of time digging into this Waters of the U.S. rule, it's complicated. Yeah. But you do understand our stress level, particularly for those of us from the arid Southwest, what some of these rules mean. I am going to ask a favor of you.
Yes, sir.
Before you, because rumor is you were leaving in about 3 weeks. In the Science Committee, there was a request from Mr. Weber from Texas, specifically asking for any of the maps that Fish and Wildlife. And I know you provided some of the maps, but we would really like to get our hands on any of the mapping that was provided by Fish and Wildlife in helping sort of design the impacts and the calculations, particularly economic impacts of this rule.
Okay, I think we may have provided those maps earlier this week, but if not, I will absolutely make sure that they go in there.
If you have, my notes may be a little bit
That's
late.
fine. You know, there's always a running back and forth between all of us. But let me just say that when I did look into that, I did discover that the maps were created as far back as 2005, and they've been updated since then. And they were not for regulatory purposes.
No,
but I think all the maps that I think we had, if they're not at the committee now, they are going to be there this week.
Well, Deputy Administrator Bob, one of our concerns was the mapping also used in trying to do some of the economic analysis and trying to understand its impact of the rules. There was one scenario that I left from last week, and I really wanted to sort of walk through, because you have personal experience on this. When you were with, was it Sierra Club before?
No, sir. It was with the National Audubon.
Oh, sorry, I should have
Bird
known that.
conservation.
And one of the projects was in our dry salt river.
Yes.
Yeah, and it's a beautiful project, you know, the rehabilitation using the gray water.
That's right.
Under this updated Waters of the U.S. rule, do you believe you'd have to get a 404 permit to do that project today?
The actual restoration?
The actual, you know, the retention, the movement, the capturing of the water, the actual project. Would that project from beginning to end today require a 404 permit? Particularly also there was some environmental damage. I mean, old batteries and other things in the area that had to be dug out.
There was a brownfield site across there, and I think, as I mentioned to you, I worked with the former mayor of Scottsdale, Sam Campana, to do that project, and it may have gotten a 404 permit. I think it was the Corps of Engineers that did that restoration, didn't they?
I think they actually did some of the water channeling.
Okay.
I think the project was separate, but I'm reaching back in my mind.
Well, down in the stream bed, where I've actually gone birding and looked at the, where there's been some water brought into there, and some vegetation is now growing to attract that in that stream bed. If there was a disturbance of the stream bed, they would have
required particularly under.
But
at
up
least
on
we're
the
looking at,
yeah,
because there's two mechanics, and I have only like 45 seconds to try to run this through. One was, in many occasions where we've actually tried to do good acts, my fear is if this gets an expansive interpretation, all of a sudden the good X, I'm now going to be required to get a 404 permit and go through those hoops. So in some ways, is there a potential we're creating a barrier to there? And I'm going to sort of leap and let you sort of combine the answers. Last time I sort of walked through a scenario of, okay, this isn't about the water, it's about anything, it's a pollutant in the water. So our little scenario of the dry wash behind my home, and I put fertilizer and plant and the sediment, in that 14 inches of rain I get a year that all come on a Tuesday. It's running down the
Monsoon.
wash and hits the Verde River, and the Verde River hits the Salt River and runs into this rehabbed riparian area. I use fertilizer. I move dirt. It potentially got washed down, that dry wash, into a running river. Did I potentially need a 404 permit in planting my tree? And what's my exposure that may not be your intent today, but the way this is drafted, there's a whole new cause of action and future litigation that's coming at us that the lawyers now get to spend the next decade moving that direction?
Well, the quick answer is, without, and I want to put the asterisks next to this. I'd love to go to your house and look at this project myself, but I would say it's highly unlikely that's significant under the way we've prepared this rule. Whereas the existing regulation, the law on the books that the Supreme Court has been opining about, has no such clarity of what's significant. It just simply says anything the field biologist thinks might have an impact downstream.
And
So,
Mr. Chairman, let's, because I'm way over time, a litigation exposure.
yeah. I mean, I think it would be less than what currently exists.
All right, thank you, Mr. Chairman.
Mr. Payne?
Thank you, Mr. Chairman. And I will follow Mr. Schweiker's lead and call you Deputy Administrator Bob. And also based on hearing that you are going to be leaving, probably after today you figured you should have left 3 weeks and a day earlier. Well, we're going to try to just get some questions answered. There's been a lot of discussion about, how the EPA's new rule can negatively affect small business. Can you, just list or describe ways that it can positively affect small business?
Well, I'll just do something very quickly here on the water definitional rule, or the waters of the United States. We firmly believe, and we heard this from the discussions we've had with small businesses, that A, they want to make sure that the law is interpreted correctly because they want clean water, but second, they want to be able to have the clarity or the certainty of what's in and what's out. And we are struggling to do that, and that is our intent, to try to do that, and we will continue to endeavor in that. On the Clean Power Plan rule that we've talked about a little bit here, one of the things that EPA has laid out there is that we want states to really seriously consider energy conservation as an important part of what their plan might be. And I know for sure that the whole sector of energy conservation, whether it be smart grids or how to make things better in your house, is going to be very oriented to small business opportunities.
Mm-hmm. As a matter of fact, through Homeland Security and the Cyber Security Bill, I have a piece of legislation that was amended into that bill and to do a smart grid study for upgrading the grid across the country and benefiting areas that tend to have natural disasters, and also looking at man-made. So that's right up my alley. Now, why are you having such a hard time getting small business to understand these issues?
Well, I think that we are spending a lot of time with small business. I know that one of the issues the committee has is why not do that under the Regulatory Flexibility Act, and it's because a lot of the impacts that may or may not accrue and a lot of the benefits that may or may not accrue depending on how these proposals unfold, will be indirect impacts or indirect opportunities. And the Regulatory Flexibility Act deals with direct impacts. So we're not regulating somebody who does an energy conservation project, with a new kind of thermostat, or we're not regulating those people, but they may have an opportunity to provide more business. So we have reached out to small businesses. We have roundtables underway with the SBA on the water rule. We are in the process of finishing up our formal hearings this week on the Clean Power Plan, and then we plan between now and when the rule is finalized, and even way before that, to spend even more time with small businesses, whether it's the small co-ops or the small municipals, or even the indirectly impacted small businesses.
Okay. And, around the whole issue, around the complexity of all of this, the Clean Water Act, increases the amount of time it takes to make jurisdictional determinations. In your estimation, how much shorter time will these jurisdictional determinations take with the proposed rules as opposed to the old ones?
Yeah, the current one, because of the way it's written, requires almost every request for or any project that might be near water for them to go through a process on a case-by-case basis with the Corps of Engineers. Well, the other thing we're trying to do here, and the intent is to have enough definition, so along the lines we were talking about earlier, Congressman, that it would reduce the number of case-by-case determinations and therefore make it more quickly apparent whether they have a jurisdictional issue or not. But I also want to point out, if you're not going to discharge pollution or put fill into the water, it wouldn't matter one way or the other.
Okay. Thank you very much, and I yield back.
Mr. Hanna.
Hey, how are you?
I'm fine.
Good. If you're trying to prove that you're trying to make things easier, you're not really doing it. As you can sense, the cynicism in this room is, at least on our side of the aisle, profound. And I don't think that it's born out of some disinterest in the environment or anything like that. I think, for one thing, your former administrator, Lisa Jackson, her comment that it wasn't her job, to paraphrase, to worry about the economy, if you remember that, was I think a scary thing to hear for everyone in the country. And the subjective nature of the conversation here today, and the notion that so much about this has the potential to be arbitrary and capricious, and the concern that the farmers and builders and contractors that I deal with daily — I was in construction for many years — it's not in any way, and I'm not surprised that you said that businesses are concerned to have clean water. I mean, who isn't? That's really not much of a statement, with all due respect, or a surprise. The problem your organization has is nobody believes you, that you have no credibility here because, frankly, people feel put upon. And the burden — I just went through almost 13 years in our community to get a 404 permit through the Army Corps of Engineers for something that was a relatively simple process. And it would appear to a lot of people I know, and I'm sure you hear this too, that the EPA is now our enemy, not our friend, that somehow everything is become so burdensome, so complicated, so drawn out, that the growth that we look for in our economy, the opportunities that lie in front of people, that you're an obstructionist organization and not someone who ushers them through the process. And for people in business, every bureaucrat that walks through their door, it feels like they're throwing an obstacle at their feet. And here you are, one more, but yet you're bigger than all the rest. And people assume that you can in some way interfere in everything, everywhere, all the time. And when they hear the definition of navigable waterways, that and people want to believe people are inclined to believe that it means the water off their roof. So when you explain that it doesn't, and I'm just telling you the way the people I work for feel, they don't believe you, and they're concerned. And if the concern seems disproportionate to your intent, which, you know, I'm listening to you, and I believe you're earnest in what you're saying, you need to back up, because frankly, the outcome that you desire is going to be pushed back at by this entire country, not because it isn't an outcome that we might all want and even agree on, but because, frankly, nobody believes you. I wonder how. I mean, I wonder how you feel about that, or if you even agree.
Well, I haven't, and nor does EPA do polling to determine who believes us or who doesn't believe us.
But you don't have to.
Well,
in this case.
let me just say what I believe. Okay, I don't believe that most people don't trust EPA. The polling I have seen, for what it's worth, back in the past by others, shows that people prefer EPA to be setting standards. And, you know, but I don't have enough data on what every person in the United States thinks about.
No, but preferring to have them set the standards is not the same as being is trusting them.
Yes, this trust thing is a problem, particularly if Congress has it. This is not an idle problem, and we need to work on that. And I'm here today trying to explain what our intent is, and to try to build a bridge.
I appreciate that, but you're not going anywhere with the presentation I see today. Backing up and blaming the Supreme Court or using them as a crutch, that also isn't helpful, because at the end of the day, this place has the ability to do what it would like to see done. We have the capacity to make mistakes here, to undo what you might regard as good work, and may very well be good work. But if you can't make us trust you in that regard, you're going to have an outcome that you don't like, and that potentially we may not like. My time is up. Thank you, Chairman.
Mr. Heelskamp.
Thank you, Mr. Chairman. Appreciate the Deputy Administrator for being here today. And if I've asked a question that has been asked before, if you could restate the answer, I would appreciate that. But one thing that many of my constituents are asking, and I share the same concerns of my other colleagues here, but trying to understand the claim from the EPA Administrator in Kansas City a couple weeks ago, and similar years here, this would provide more certainty compared to your current regulations. Can you tell me if this regulation would allow the federal control or regulation of ephemeral streams?
If it would make ephemeral streams jurisdictional if they exhibit those hydrologic characteristics that would be an indicator of significant and frequent enough flow.
Would that
be significant?
Would that, yeah, then we get a definition of what's significant, and I've been through this at the state level. Would this increase or decrease the amount of Clean Water Act jurisdiction compared to current law?
We believe it would reduce.
It would reduce that. Have any states suggested otherwise in their comments?
I haven't read the state comments yet.
Have you read any comments about the rule?
Well, the comment period is open until, I think, October.
You haven't peeked at them a little bit early?
Well, I've been out talking to some states. I was in Oregon
Have any states indicated that
and
they disagree with the assessment that it reduces?
I haven't heard that, but
Well, I'll give you a clue. In Kansas, the state of Kansas, estimates are from our state. It increases the jurisdiction by 400%. 400% more jurisdiction under the proposed rule. Instead of regulating 32,000 miles of stream miles, it would increase that to 134,000 miles. How could they be that wrong? You're claiming the jurisdiction goes down. The state of Kansas actually lives there. Yeah. And we worry about our environment. As a farmer myself, I consider myself the first environmentalist. How could they be so wrong in misunderstanding of your rule?
I would love to see their analysis, and I'd love to get our staff to sit down with them and understand why that we see such a different situation. I know that more than half the states already cover ephemeral streams themselves, including Kansas.
The issue is
including Kansas.
not under the Clean Water Act, sir. The issue here, I also asked one about is navigable. Can you describe or define navigable for the committee, please?
The navigable in the Webster Dictionary.
No, in
the
your
Clean
legal
Water Act,
dictionary.
in the Clean Water Act, the navigable has been defined by Congress as waters of the United States. That's what the definition is in the Clean Water Act of 1972, and the Supreme Court.
No, navigable is an adjective, not describing the waters of the U.S. It's a limit on the jurisdiction of the Clean Water Act. It doesn't describe every water of the U.S., sir. You are clearly wrong.
Well,
can you define navigable? That
navigable
is a limit on the power.
The navigable waters include waters that flow into traditionally navigable waters that can have an impact on the biological, chemical, and physical integrity of those navigable waters.
So navigable water is water that flows into a navigable stream? So non-navigable waters, by that definition, become navigable?
No, waters of the United States.
Waters of the U.S. do include non-navigable waters, is that correct?
Yes.
Okay, so there's a distinction. So what
they
you've done now
include
with
the
your
waters. The Clean Water Act is looking about controlling water pollution. And controlling water pollution, even if
the authority of the federal government is limited to navigable waters.
And controlling water pollution that could enter it.
Under navigable waters.
And
here's a
water
question
pollution
for
enters
clarification.
Water pollution
This
enters
is a,
from other streams.
You believe this is going to bring some certainty. Here's a body of water in western Kansas. It actually rained once upon a time. This was a few weeks ago. Is this a navigable stream?
It is neither navigable or waters of or jurisdictional under the Clean Water Act.
You can guarantee me today that this will not be under the jurisdiction of the EPA.
You know, I'm just not going to go any further than what I just said because that's just unfair. I have to go out and look at that, but it looks like wetness in a field which would not be navigable, which would not be
But it might flow down the road ditch to a navigable stream.
Doesn't matter. It doesn't exhibit the characteristics that I mentioned earlier, or the hydric soils, or the hydric vegetation. That is a puddle in a field, and it would not be covered.
So you can absolutely guarantee me a puddle in a field, a road ditch in western Kansas will not be covered, guaranteed not covered under this new regulation.
A road ditch that's not a channelized stream would not be covered. Some road ditches actually are channelizing a stream, but putting that aside, road ditches for the vast majority of them are not going to be covered, not be jurisdictional, and wet fields are not going to be jurisdictional. They're not going to be jurisdictional.
I yield back, Mr. Chairman.
Ranking Member Velasquez.
Mr. Chairman, I would like to ask unanimous consent to submit for the record a report from the American Sustainable Business Council that found that small business owners are concerned about climate change. 57% are concerned about carbon pollution, 53% are concerned about climate change, and 53% believe climate change will adversely affect their businesses.
Without objection.
Thank you.
Mr. Lukemeyer.
Thank you, Mr. Chairman. Just a couple of questions, sir. With regards to power plant oversight, I know that apparently, correct me if I'm wrong here, that it appears that the agency, when they figure the costs of the rules and regulations in power plant rules, that they consider it on a global scale. Is that correct? The cost benefit on a global scale.
Well, I'm not exactly sure of the term there, but when we look at,
you take other factors besides what would be we could consider domestic, things that would affect only the United States. Do you take into effect whatever cost savings or costs otherwise may be affecting other areas of the world, our neighbors to the north, south, east, west?
I don't know the answer to that. I'm going to say generally no. But there have been instances where obviously we've cooperated with other governments like Canada on acid rain, where we've done joint work together. But I would generally say we were looking at the impact in the United States.
Well, what I've been told is that this you do take into account calculating benefits on a global scale for coal referenced rules, which have a dramatic impact on coal-fired electrical generation plants, of which I've got a couple in my district. In fact, one closed up as a result partially of the rules that have come down. And I'm just kind of curious why you included the costs of savings or other benefits of other countries over what should be, I would think, only the costs benefits that would be for us domestically.
Yeah, I really apologize. I should know what you're asking, but I don't want to guess. So if it's okay with the committee and the chair, I would like to be able
we can
research that and provide the answer.
Other than that, I'm just one other concern. When you go down the road with these different rules and regulations that you're looking at, basically the President seems to be trying to implement carbon tax rules around the Congress by implementing some of the rules that through your agency. I think it's very, very concerning. I think again, when you do this, you need to go through the RFA process to find the effect on small business. And it's very concerning to me that we're even going down this road when you look at what Australia just did. Australia implemented the carbon tax 2 years ago and found it increased costs significantly, over 15%, and affected thousands and thousands of jobs, and they now have withdrawn that. I think we need to be very careful down the road that we're going down, and we need to make sure we continue to adhere to the process and the procedures that are in place, which today we're talking about the Regulatory Flexibility Act. It's a very, very important tool for analysis, and not only for you, but for us, to make sure that the rules that you're putting in place are something that we could go along with, that we believe our constituents, our small businesses are having to live under, and would be beneficial to them rather than costing them. Again, when you see what's coming out of other countries with regards to the kind of power plant rule and regulation that is being proposed, and they're backing off, it should give us pause. And for certain, to be able to cause, I would think, be a red flag to make sure you adhere to the process and procedures. And with that, if you want to respond, fine, sir.
Sure. Just a couple of quick comments. First of all, I want to be really clear to the committee. We believe that we should be looking at the impacts of all different segments, whether it's small business or large business. I just want to be really clear about that. And somebody at EPA did make the statement earlier that it's not in our job description, but it was not Lisa Jackson, I can assure you that. It was not. It was a lower-level EPA employee who made a mistake. That's all I want to say, made a mistake. Now,
to follow up on that, sir, before you move on to your next comment, that's why it's important that you do the RFA, because that affects the economic concerns that we have. And when you have a comment like that, that gives us pause. I'm sorry. Go ahead.
So there are two things where I want to make it clear that we're not trying to implement a carbon tax or anything like that here. The Clean Air Act gives us very specific authority to look at sectors. And so in the last term, we did a light-duty vehicle regulation to reduce the greenhouse gases from light-duty vehicles. We worked with the Department of Transportation on that to make sure it aligned so that the automobile manufacturers only had one thing to implement between the CAFE and the carbon rules. We reached consensus with the automobile manufacturers. We had a process with the small automobile manufacturers. We exempted them from the rule completely. And then they came back to us and said, we want to be able to opt in if we're making really efficient cars because we want to sell our credits to the other automobile manufacturers. And so we actually have an opt-in for small businesses in that rule. So I don't want you to think we don't really do think about this. And that's the two big carbon so-called carbon rules that EPA is working on. One was the automobiles, which is in the process of being implemented now and has those kinds of provisions I just mentioned. And the other one, which is the power plants, which we haven't implemented yet, which is going to be something we're going to have to work out with states, where we are going to be continually looking for ways that we can incorporate ideas and opportunities like that to be able to deal with small businesses. And we hope that many small businesses will capitalize on some of the business opportunities as well. But we do look at this. I want you to believe that and not trust us.
Thank you for your comments. I yield back. Thank you, Mr.
Payne.
Chairman.
Mr. Tipton?
Thank you, Mr. Chairman. I would like to associate myself with many of the questions and comments of Mr. Lochtmeyer, because one issue, and Deputy Administrator, does it disturb you a little bit when you were just talking about, and that's admirable that they were able to achieve this, but some of the small car companies wanting to be able to sell their does it disturb you when we talk about the sense of Congress, which created the EPA, by the way, had rejected cap and trade? And effectively now we're seeing it moving forward in a regulatory action.
Sorry,
I was just quoting you. You were just saying that they wanted to be able to use their credits in regards to
this is just between the car. We always do this in our rules.
Yeah.
In all of our automobile rules, if one automobile manufacturer does a better job of pollution control than others, they can move those credits around between the automobiles, but they can't sell it to a power plant or vice versa. It's inside. Market mechanisms has been something EPA has used in rulemaking going back to the early 1980s.
Yes, sir, and I understand that, but I guess my point is Congress had rejected under a Democrat administration cap and trade, and
this is not a cap and trade program. This is the ability to trade credits in between. Again, we've been doing it since the 80s.
And I think that's really part of the concern, is we see stepping stones to movement. If we go back to water, when Secretary Salazar, Secretary of Interior, was initiating, were you familiar with the Blue Ways program?
No, sir.
Blue Ways was coming out of the Department of Interior, which is effectively a precursor to the waters of the U.S. And I'd invite you or your successor to make sure that they read the reports that were coming out of the Blue Ways program, effectively citing pollutants coming from faraway farmlands in the Midwest. And it effectively really goes to Mr. Schweikert's point in terms of once water is put on, the picture that Mr. Hulskamp had shown you, we may not define that as navigable, but as it flows down, effectively that backflow becomes all navigable waters. And that's really the concern that people have is once you start regulating, it does have impacts and those costs that are going to be associated with it. Through this committee, we actually have the empirical evidence that through regulatory costs in this country right now, Americans are paying $1.8 trillion in regulatory costs. And no one is suggesting we get rid of all regulations. But those are real costs. And right now in Colorado, yesterday, you held EPA hearings, and unfortunately you held them in Denver. We sent 2 letters to the director requesting that the hearing actually be held in the impacted area over in Craig, Colorado, Moffett County in my district. We received no response from the EPA. Would it be appropriate when we're holding these hearings, and I think you've heard loud and clear the importance of these RFAs, to actually go to the impacted communities rather than just going to urban areas for hearings?
Well, the hearings are just one aspect of our outreach, and we've tried to distribute them around the country into different different parts of the country so people have an opportunity. But let me just say this categorically: EPA will meet with anybody who wants to meet with us on this, and we are going to reach out to virtually every state and the constituencies in each one of those states, and we're in the process of doing that.
Great. Can we get a hold of you, and you will help facilitate with us for Director Jackson to be able to come to Craig, Colorado, and we will meet with them?
Well, you tell me who it is that we're meeting. I'll try to figure out.
We're going to be able to meet with community members, with county commissioners, state legislators, the impacted private entities in rural Colorado that are going to be impacted by proposed EPA rules?
So we would want to work with the state of Colorado because they're the ones that are going to have to implement it.
And you will be willing to come
I'm
to Colorado?
I'm willing to get on the phone and get with the governor and try to figure out how we do that.
Great. We'd love to be able to have you come in. And I think when we're talking a little bit about
how to have a meeting here. I don't know where the meeting will be, but we'll have a meeting.
Okay. And I think that is part of the problem. We just had rural Coloradoans had to drive 4.5, 6 hours to be able to go to the meeting in Denver, Colorado. It is important that when we're talking about outreach, I think not to discard rural America because these are some of where the real impacts. And when we're talking about the states are going to have to implement it, do you share with me some of the concern when we're looking about some of the carbon credits? If you want to be able to see blue skies and a coal-fired power plant, come to Craig, Colorado with me. We'll be able to see that. But the concern that we are hearing, and these are out of senior citizens that are on fixed incomes, young families that are just trying to be able to get started, they're seeing taxation via regulation to where those utility bills continue to climb. Is this taken into consideration at all by the EPA?
Our economic analysis shows that energy bills will decline.
When?
Between now and 2030, the energy bills will.
If I'm paying $100, it's actually going to go down?
Our national estimate, remember we're doing national estimate, is that energy bills will decline 8 to 9%.
And I'd love to see that study.
That's in our regulatory impact analysis.
We'll certainly have
and
to
we
pull
can
that
point that out if the committee would need to have that.
Great. Thank you, Mr. Chairman. I yield back. Thanks,
Collins.
Yeah, I'd be brief here. Just in looking through some of the rules and use of terminology, I think what seems to be bothering a lot of people, words like significant. And here in the proposed rule on the Federal Register, it says for an effect to be significant, it must be more than speculative or insubstantial. Now, so when we use that word, is there any data behind that that would suggest what that means?
Yeah, that's one of the things we're trying to deal with. I believe, I may be wrong, and somebody behind me may be able to clarify, I believe that that's just the language that the Supreme Court used, and what we're trying to do with the rest of the rule is actually try to put a boundary on that.
Yeah, this is actually out of the regulatory text, not this.
So, well, I mean, we were probably writing that in there, but Justice Kennedy's opinion. So what we've done with the rest of the rule is try to say, well, what would that be? And it gets back to trying to do it on a scientific basis as opposed to does it affect down.
Yeah, the problem is a small business in trying to adhere to something and reading through this, they're not going to know where to take something using a word like significant. Right. So I guess I would conclude simply in saying, well, let me also go to another point today. Too many times in Congress with the public, it looks like the EPA has a, quote, solution looking for a problem. So today in our science hearing on the coal plants, a data point came out that said if the United States industrial complex and the United States power generation complex produced no CO2 whatsoever, none. They were all shut down. How would that impact the amount of CO2 going into the atmosphere in the world? And the answer was 2%. So here we are. So we could shut down all of the power plants. We could stop all of our production that emits any CO2. The impact in the world is quite insignificant, negligible, de minimis. 2% is not going to have an impact, not given what we're doing. So that's part of the issue, and I say the frustration on our side is the need for jobs, the growing economy, and then having the EPA overreach for something that's not needed. Again, a solution that's looking for a problem that doesn't exist, certainly not that we could have any impact on. So it's just interesting. You, I believe, admitted there's a trust factor between the EPA and Congress. Clearly. There's a trust factor between our farmers. And I always have a saying, don't bring me a problem without a solution. The EPA has a real problem. Congress doesn't trust you. Farmers don't trust you. The public doesn't trust you. So what's the solution? Don't bring me a problem without a solution. It's a simple solution. Withdraw the rule. Start over. Understand what you've done wrong. Reach out. Study the small business. Go do the RFA. That would mean so much to, I think, this Congress and the country for the EPA to say, we were wrong, we got ahead of ourselves, we admit that there's misunderstanding, we're going to withdraw the rule, take all this into account, and since there's no judicial deadline, we'll move forward on another day. You know, we screwed up. You know what that would do for your trust factor in Congress? It would take you a long way. So all I would say, I know you're leaving, but for my 2 cents worth, if you could convince your superiors to withdraw this rule, your credibility would skyrocket in the EPA. And I'd suggest you seriously consider it. I yield back.
Mr. Schweikert.
Thank you, Mr. Chairman. Deputy Administrator Peresepi, sort of a continuation on a bit of the thought exercise here. Significant nexus. Ultimately, I believe in your testimony, the discussion was this rewrite, this update of waters of the U.S. has been driven because of multiple Supreme Court rulings?
Right. Keep in mind, it's a definitional rule, so it's defining something. We had it defined in the 80s and the 70s on a very broad way. The Supreme Court has several times said you can't use that approach. You need to come up with a different approach.
And some of the significant nexus language actually came out of the Supreme Court language.
That's right.
I'm going to ask you actually for a personal opinion, and I know this is a little awkward then, instead of your hat as the Deputy Administrator, but you're leaving in 3 weeks, so you're allowed to have a personal opinion.
I am a citizen of the United States.
Over the next decade, your personal opinion of how much litigation is ultimately going to take place in defining significant nexus, because the regional differentiation of that is incredible. If you think about our lives out in the desert Southwest compared to other parts of the country. So where I'm heading on this is your personal opinion, how much litigation are we going to look at in just, once again, as soon as this rule, if this rule goes into effect as written, in fixing these definitions or tightening them up or politicizing them or moving them? I mean, what do we expect to see?
You know, maybe it's sort of and also a little bit toward Mr. Collins, who just had to leave, answer. You know, I can tell you that Gina McCarthy and Bob Percisepi, as long as I'm here, but certainly my immediate supervisor or boss, Gina McCarthy, want nothing more than to build credibility and confidence in the Congress. So from a personal perspective, we would hope that we would be able to get out of the situation we've been in for 40 years with everything keeping going to the Supreme Court and try to get it to stop. And at some point, you know, which I don't see, if we do nothing, it will continue to keep going up there and they'll continue to keep
But
saying.
if you also do this, I mean, you know, in many ways, the term significant nexus is a new term of art. And now we have to define it.
Right.
And is a significant nexus different in Oregon compared to the desert Southwest? Is it different in,
Yes.
you know, building that box? And where you're hearing a lot of stress in our voices is for places like Maricopa County, Arizona, you know, one of the third, fourth most populous county in the country. We recycle every drop of our water, every drop of it. We think we do some of this really, really well.
Yep.
Is there going to be litigation that's being driven on another, you know, how water, the significant nexus of water in Delaware, and all of a sudden we find that the way we operate in our region, we're back in court having to redefine for a definition that works for us.
The old one.
In my minute and a half I have left, you actually just touched on something. You've heard the credibility discussion, distrust discussion. Could you share with Administrator McCarthy two things from me? if you have the chance. One is stop giving speeches where you vilify us, where in your language you say you're going to go after those of us who have questions, where that only real scientists are worthy. And those are quotes from articles. You didn't say them, but the administrator did. And the second part of that is transparency. It's not good enough to tell us what your study says. We need the data sets. It is unacceptable to have proprietary data saying, well, we hired a contractor to do it. You need, if you're going to make public policy needs to be done by public data. The public deserves the right, left, activist, researcher, to see the base data sets and model it. Because I think actually some of the distrust comes from the inability to see that baseline data and know you could stress it and reproduce it. So that's more of an editorial comment, but I actually think it would take us a long ways to openness, transparency, and rehabilitating the relationships between the agency and the public. Thank you, Mr. Chairman.
Thank you, Mr. Perciasepi, for coming in. And I might suggest, because you've said several occasions today, you're seeking input, you want to, and we've been talking about credibility and transparency, and you want to hear from the business community, but I would suggest that you comply with the RFA, and why not do it voluntarily? Why not go through the steps that are laid out, and help your credibility out considerably, and do it through the process, because that's really what this hearing is about, is why the EPA does not follow the Regulatory Flexibility Act, which is what this committee is all about. And it does require all agencies, the EPA included, to conduct outreach and assess the impacts and rules on small businesses. And hearing from those small businesses early in the rulemaking process is going to identify these problems that come up, and hopefully, as has been pointed out, produce better solutions and better rules. But unfortunately, EPA is not complying with the RFA, and the result, it's confusing. It ends up badly crafted regulations, and you get into situations like you're in. But the committee is going to continue to engage with the EPA to make sure it fully complies with the EPA or with the Regulatory Flexibility Act. And with that, I'd ask unanimous consent that all members have 5 legislative days to submit statements and supporting materials for the record. And without objection, that is so ordered. And with that, the hearing is adjourned. Thank you.